This is Protected Thoughts from the Intellectual Property Team at McBrayer. This is an overview of state or federal law and regulation and does not constitute legal advice. Services may be performed by others. For more information, visit mcbrayerfirm.com.
Welcome to Protected Thoughts. I am Mary Louise Paul, and I'm here with Bruce Paul.
Howdy.
Good evening, Bruce.
Good evening again.
We're back tonight to talk about Donald Trump. No, this is not a political podcast, I promise. This is bipartisan. We are here to report the trademark law, the intellectual property law, and just give our opinions on the law. But he is in the news a lot this summer relating to intellectual property law, and we just have to talk about it. Tonight, we are going to talk about a Supreme Court decision involving...
The case is called Vidal versus Elster. It's a case where we would call him is a trademark registrant. A person wanted to register the mark with the U.S. Trademark Office of Trump Too Small. Now,
before we go any further, Bruce, can you tell our loyal listeners about the origin of this trademark? I was familiar with the case and the history of the case, but Bruce enlightened me by sharing this video clip a few moments ago. And so can we do the PG version of the clip that is the origin of this Trump Too Small trademark?
I mean, I can't describe it comfortably, but...
Well, let's hear it.
So in March of 2016, I believe it was way back when Donald Trump was running in the Republican primary to become president the first time, and Senator Marco Rubio from Florida decided to go after the size of Donald Trump's hands and whatever suggestions might be associated with that. And so if there's some good video on it, he apparently brought it up at a rally, and Donald Trump couldn't stop talking about it, how he has big, beautiful hands. And
no one's ever complained about the size of his hands.
Beautiful hands.
Yeah.
And they actually engaged about the topic during a debate. And, so what entrepreneurial soul decided to take advantage of that by registering a trademark, Trump Too Small?
Not registering, applying to register a trademark, because this application for Trump Too Small was denied registration by the United States Patent and Trademark Office, and that is eventually how it came to be a Supreme Court decision.
Why was it denied?
It was denied registration because the application identifies a particular living individual. Obviously, the mark contains the name Trump, so it identifies Donald Trump. And when you apply to register a trademark application, one of the things that the Trademark Office requires you to do, if the mark contains the name of an individual, is check a box to say you've obtained the consent of this living individual, or the mark does not identify a living individual. In this case, obviously, the applicant did identify a living individual through his mark, and he had not obtained the consent, so he couldn't do that. He argued that this provision of the Lanham Act that requires him to identify a particular living individual violated his First Amendment rights.
Right. There was let's back up. There are lots of Trumps. There's Mary Trump. There's Eric Trump. There's Donald Trump Jr., Ivanka Trump, Melania Trump. Did he have to get Donald Trump's written permission to apply for that mark?
Oh, he didn't get any Trump.
Okay. Would it have been approved if he would have gotten Mary Trump's, who is, I think, the niece of Donald Trump and famously a famous opponent to Donald Trump?
I can't say for certain it would be approved, likely, although the statute does say a particular living individual, and obviously he, in this application, the particular living individual, based on the clip that we know this originated from is Mr. Donald Trump. So to deny that you were talking about Mr. Donald Trump and trying to get, I don't know, Barron, he's over 18 now, right? He could consent to Melania, let's say. Her consent probably wouldn't work because the trademark office will come back and say, from the context of this, it doesn't look to me, the examining attorney, I mean, will come back and say, it doesn't look to me like you are talking about Melania. The context clues here or the evidence suggests that maybe you're looking at someone else. Now, if you got lucky and you, I don't know, lied to the trademark office, which you can't do because you're filing things under the penalty of perjury, or you said that this was not that particular living individual, maybe you could slide it by. But again, you can't do that because you're making attestations in the filing that have to be true and accurate.
So the United States Patent and Trademark Office refused registration. He appealed it through the TTAB, I guess, is who he would have appealed it through. His argument, as you said, was that the denial of registration violated his First Amendment rights. There are some semi-recent cases discussing that, Mattal versus Tom, and a case called Brunetti. Tom was pretty famous in my mind. It involved a band, a rock band by the name of the Slants, where the lead musician wanted to register the name Slants. That lead musician is Asian American. It was denied by the Patent and Trademark Office as an offensive mark, and he challenged it. What happened in that case?
So you are correct that in this case, this was back in, June of 2017. This rose to the Supreme Court. And the Supreme Court struck down the ban on registering disparaging marks under Section 2A of the Lanham Act. The Lanham Act, as we discussed in the last podcast, is the federal statute that governs trademark law. The Supreme Court deemed the statute that bans the registration of disparaging trademarks unconstitutional under the First Amendment. So in that case, the United States Patent and Trademark Office refused to register the mark the Slants for use in connection with entertainment in the nature of live performances by a musical band on the ground that the mark was disparaging to Asian Americans. Allegedly, the Slants, you said the lead singer of the Slants was Asian American, and he selected that mark to pay homage to his Asian heritage and to, quote, take back a term that was once viewed as a racial slur. Now, the evidence suggests that the term the Slants is still viewed by many in the Asian community as a racial slur. So there's also some interesting commentary here, and we can have a discussion as to who gets to decide what is offensive, disparaging, and what's considered a racial slur and is not. And, if some find it offensive, should it be registrable? If some don't, should it be registrable? But ultimately, the Supreme Court made the decision that it is unconstitutional to prevent registration of a mark that's considered disparaging. So the USPTO, in refusing to register the Slants, had cited Section 2A of the Lanham Act, which prohibits registration of marks that may disparage or bring into contempt or disrepute any person living or dead. And the USPTO had previously used a two-part test to determine whether a mark was disparaging. The first part of the test involved determining the likely meaning of the mark at issue, and the second part was determining whether the mark was disparaging to a substantial composite of the referenced group. And when the ruling came down from the USPTO, TAM appealed that ruling to the Federal Circuit, and then ultimately it reached the Supreme Court, and it was unanimous by the Supreme Court that the disparagement clause was unconstitutional.
Yeah, so that test you just laid out is now dead, right?
Yeah.
That provision of the statute is gone, and what the court ultimately ruled there, this was a different era of the United States Supreme Court back in 2017. The ruling effectively said that provision in the Lanham Act was content-based restrictions are described as, quote, particularly egregious forms of content discrimination. They've been called blatant First Amendment violations, and therefore the court said that unless the government can show some reason, some compelling state interest for requiring that provision, then it is presumptively unconstitutional. So that provision is dead, dead in the water. And Brunetti met a similar fate, right? There it was a case involving a quote-unquote scandalous or immoral mark that Brunetti wanted to register, right?
Yes, and this, 2 years later, June 2019, the Supreme Court struck down the Lanham Act's ban on registration of immoral or scandalous marks as a violation of the First Amendment. So in this case, the applicant wanted to register the mark FUCT. This was apparently an acronym for Friends You Can't Trust. It was supposed to be, apparently, pronounced as 4 letters, FUCT, but when you look at it or you read it, it is the past participle of perhaps your favorite swear word. I don't know, I think there's some other good swear words out there, but many like that old F word.
Whoa, I'm looking at the FUCT.com website, and it is alive and well with a naked woman riding a motorcycle.
Oh, but you know what? Do you remember that brand, French Connection UK? They've been using FCUK for years and years and years. Obviously, I probably didn't try to register it prior to this, but I remember the shock value of FCUK years ago.
Well, again, talking about this is more fun than the actual case. The case was found that mark was permitted to be registered. Again, same standard applied to the Tam case was applied, that it was not content neutral discrimination, but content specific discrimination. The United States government couldn't provide a compelling reason, or that its statute was narrowly tailored to satisfy that compelling reason to prohibit that speech, and therefore it was also dead in the water. By the way, there's an interesting product on this website. It's, I just have to say this, it's a trademark podcast, right? It is we're in Louisville, Kentucky. Ford's a big company around here. There's the Ford logo with FUCT in the middle of it. Now, if that's not...
That feels a little bit like, I'm certain that, I don't know actually, but it feels like maybe Ford is not supportive of this.
Don't know. Anywho.
Okay, back to this decision. In Brunetti, the majority opinion determined that the prevention of the registration of a immoral or scandalous trademark infringed the First Amendment because it was viewpoint-based and it disfavored certain ideas.
Yeah, again, content discrimination. So, circling back to 2024 and the Trump to small mark, the applicant there argued that this is content neutral. There's nothing discriminatory. There's nothing specific against anyone. It's just a statement. It's content neutral. It would, if it were Biden too small or Harris too small or Rubio too small, whoever too small, it would be content neutral. It's not really saying anything. So, Mary Lise, you want to describe how the court came down on it?
The court determined that the statute was constitutional and that it is acceptable to require consent to register a trademark that includes the name of a particular living individual.
So, again, 9-0 decision. I don't know, I know Tam was a 9-0 decision. Was the Brunetti decision also 9-0?
Mm-mm.
No, it wasn't. So this one was 9-0, but different paths to the 9-0 in this case. It was a Justice Thomas written decision, and as is when the majority or when 2 or 3 members of the majority write these opinions these days, they use a text history tradition analysis. So earlier we were talking about the Tam case and the Brunetti case and how they applied what's called strict scrutiny. Anyone who's been to law school knows that there are constitutional tests that we're all taught about: strict scrutiny, intermediate scrutiny, rational basis is the lowest level. In the current era of opinion writing, though, justices have taken to this text history and tradition analysis. And Justice Thomas starts out by just going through the history of trademark law. He goes back to England. He talks about the founding, as any good originalist or textualist would argue that the question is not what the current meaning of the Constitution is, but what was the understanding of trademarks when the Constitution was ratified in the United States. And he goes through this history and says there's always been a right to trademarks, but there's always been a coexisting right to for living individuals to have to sign off on those trademarks. He talks about Massachusetts case involving Thomsonian medicines. He talks about Taylor's Persian threads. It's just, it's this laundry list of his sort of historical analogs and some good language. He cites the Judge Learned Hand and says, a person's trademark is his authentic seal, and if another uses it, he borrows the owner's reputation, whose quality no longer lies within his own control. This is an injury, even though the borrower does not like or tarnish it, or divert any sales by its use for a reputation. Even though the borrower does not tarnish it or divert any sales by its use for a reputation, like a face is the symbol of its possessor and creator, and another can only use it as a mask. Some pretty compelling language, in my opinion, to basically say, my name is my name. I mean, it's a Marlo Stanfield line, actually, from The Wire. My name is my name. And so the idea rings true, and that's some pretty compelling language from Justice Thomas, and everyone agreed with the decision, but not everyone agreed with the analysis. Before I go on with some of the concurrences, Mary Lise, do you have any thoughts on any of
No,
that?
keep it going.
So what I think is fascinating in the current composition of the court is you do have what are frequently referred to as Federalist Society judges who are originalists, textualists who employ this text history tradition, but not everyone's aligned. And Justice Barrett, and that's Amy Coney Barrett, really hits her stride, I think, in this opinion, where she talks about and note that she is a Trump appointee. She is a Federalist Society judge. She is conservative for sure, but she doesn't dig Justice Thomas's analysis. And she agrees with the decision, which is what a concurrence is, but she basically calls out Justice Thomas and says, I don't know what history books you're reading, because as I'm doing my history, as I'm looking through my historical analogs on these issues, I'm finding a different history. She cites, actually, there is a history of cases where brassieres and collar stays and other products used living people's names in the trademarks without any sign off. And so she basically is saying, I agree with your decision that and she focuses on source identifying aspect of a trademark. Of course, a trademark, the whole purposes of a trademark, or the fundamental analysis of a trademark is this source identifying? Does it say who is sponsoring or supporting this product? And so she wants to apply a test that focuses on that source of identifying nature rather than going back through the history and tradition, because, candidly, she says, we all can look at our history books and find different history lessons. And so how are we supposed to write these decisions when we all have when we all find different points in history to support our position? Justice Sotomayor comes out swinging and says, what are you all doing here? It's your all's different history tests tell us that this history and tradition test is nonsense. she says that this back and forth highlights the indeterminacy of the court's history and tradition inquiry, which one might aptly describe as the equivalent of entering a crowded cocktail party and looking over everyone's heads to find your own friends, which is nice, a nice way of saying, a very Sotomayor way of saying, if you look hard enough, you can find something that fits your perspective. So she says that we have tests in place. The tests that are in place support Trump too small being rejected by the PTO, and that rule being an appropriate content neutral restriction. So that distinguishes this from the slants and from the FCUT. What is it?
FUCT.
FUCT.
The past participle of everyone's
right.
favorite swear.
So that's it. That's the case. Interesting case. Sort of the topic is interesting because it's got some political sizzle in election season right now, but it's also interesting if you care about how different judges apply their analysis and what they think about each other's analysis, even if they're on the same team, so to speak.
It is interesting, and during this season, Trump has managed to stay in the news regardless of whether he's the one creating the news or not. So maybe next podcast we will find some topics that don't involve politics.
Probably safer ground to be doing podcasts on.
Yes. We've got some good content coming up for our next podcast. So stay tuned and we will be back soon. And as a reminder, we're lawyers, but we're not your lawyers. We do love talking about the law, though. We'll see you back here next time on Protected Thoughts. Check us out on mcbrayerfirm.com. See you later, Bruce.
Have a good night.
All content copyright 2024 McBrayer PLLC. All rights reserved.